We are here with the two candidates running for circuit judge in the Ninth Circuit, which covers Orange and Osceola counties. It's Group 32. Welcome.
Thank you.
We are going to start out this meeting the way we start out most of our meetings, with a couple of basic questions and we ask these of virtually every candidate who comes in here. And the first question I'll start with Ms. Strowbridge. Have you ever declared bankruptcy?
I have never.
Okay. Ms. Tennis?
No, I have not.
Okay. All right. And then the next question is, have you ever been arrested, Ms. Strowbridge?
I have not.
Ms. Tennis?
Yes, I was. Would you like details?
Sure.
I was arrested in 2001 after being stopped in my vehicle. I was charged with DUI. I was found not guilty by a jury sometime later. It was a painful and embarrassing period. I certainly learned a lot from it. As with most of life's teachable moments, it was difficult, but I got through that, and I've gone the last 13 plus years thriving and surviving.
All right.
Were those the only arrests?
Yes.
Now we have our report here that mentions some possible arrests involving, here it is, a bad worthless check and also a misdemeanor arrest where the offense was not specified in 1990.
I have never been arrested other than a DUI.
Okay, so these aren't you then?
I'm telling you, I've never been arrested other than the DUI. There was a bad check that was written sometime in college that I became aware of while I honestly don't remember if I had started law school or not. I paid it. I was not arrested. I was not taken to the station. I never went to court. I never saw a charging document. I was made aware of the outstanding, I'm not sure what check, and I paid it, and that was the end of it. And the other incident, I have absolutely no idea what you're talking about.
Okay, thank you.
Ms. Strowbridge, why are you running for judge?
I think that the Ninth Circuit needs the expertise that I have. I've spent 25 years working in the area of children and families law with board certifications in marital and family law and in adoption law. I think that the family division and the juvenile division of our circuit court is a large division and doesn't have very many judges with deep experience in that area. So I think that I can serve the community in a constructive way there.
Okay, Ms. Tennis, same question.
I've had 22 years worth of experience in trial courts of all different varieties, in criminal court all the way up to 75 plus jury trials, murder trials, capital cases, death penalty cases. I've had experience in family court, in complex divorce cases, paternity cases, up through appeals. I've experience in delinquency court and dependency court. I think that at this point in my career, I'm ready for A, new challenge, and B, the ability to impact more families in a more meaningful way. I've loved being a courtroom lawyer. I love the process. I love helping people and advocating for people. But when you're doing that, you're doing it from one point of view, from one spot in the courtroom. It is not possible to take everybody's needs and wants and desires and argument into account, because your job is really to advocate one side. And I'm ready to elevate my position and my perspective and have a greater impact.
Have either of you ever run for judge before?
I have not, but I was married to a circuit court judge for 15 years, so I have a great deal of experience in what the job entails as a result of living with my husband, who's the late Bob Waddles, and he passed away in 2010.
And you, Ms. Tennis?
I have never run for any type of office before, so it's been quite a growth experience.
Okay.
Have you ever applied for any vacancies before?
I have not.
Ms. Strowbridge?
I have. I have applied on a number of occasions to the Judicial Nominating Commission. I want to say maybe perhaps 4 times I've applied, all within the last year and a half, 2 years. There were a number in a very short period of time, and I applied for each one of them as they came along.
Any theories as to why you didn't get picked?
I think that it's important for the members of the JNC to know who they're recommending to the governor. When I first applied to the JNC, I didn't know a single person on the commission. As time went on, I got to know them a little bit better, and I was told that as time went on, I was received more favorably, but I think it's a human dynamic.
Okay.
Well, Ms. Tennis, what separates you from the competition in this race?
I think my level of experience in the courtroom. I'm the only death penalty qualified candidate. Again, I believe I'm the only candidate who has jury trial experience. To me, that's a huge issue. Criminal courts today are so much more crowded docket-wise than they were when I started practicing criminal law 22 years ago. You have dockets upward of 5,000 to 6,000 cases. It is not a place to learn as you go, in my opinion. The jury process has become more and more complicated, both due to the serious nature of the cases we get around here. We have a lot of murders, I'm not sure if you've noticed. We also have a lot of high-profile cases, and a lot of that has to do with our open records laws and the fact that discovery is generally available to media. And I think it just gets more attention from the public. The judges that I have seen and who have reacted the best in those situations are the judges who have prior experience in court, prior experience on the criminal bench, and so that is a particular concern of mine. So I think that sets me apart. I also believe I have a superior demeanor and temperament for the job, and I think that's critical. We see a lot of that lately, both in the judicial polls and videos out of courtrooms. It's a pressure cooker of a job. It's a full-time, full-pressure job, and I think people take in the personalities they have, and if you go in one way, that robe is only going to make you more that way. So I think I have shown myself to be of a particularly good temperament for that position.
Mm-hmm. And you, Ms. Strowbridge?
Well, I think that I've shown that I have a career marked by excellence. I have achieved 2 board certifications, one in 1996 and another in 2011. Board certifications require that you not only pass an additional bar exam, but that you pass a peer review of both other attorneys and judges as to your qualifications and your demeanor, and your professionalism. So I certainly think that in addition to the fact that I've served as an adjunct professor of law for 10 years at Barry Law School, I have been nominated to and admitted to 2 national academies. I'm a fellow of the American Academy of Adoption Attorneys and a fellow of the American Academy of Assisted Reproductive Technology Attorneys. Both of those, again, require a high level of respect from your peers in order to be admitted to them. I've served as the president of our statewide professional organization in the area of adoption, the Florida Adoption Council, and I've served 12 years on the executive board of that. I founded and run a 501c3 nonprofit adoption agency in addition to my law practice. And during that time, I've also raised 5 children successfully. And so I think that I've shown a level of excellence as to demeanor and temperament. I'm not sure if there was a suggestion that I don't have an appropriate demeanor and temperament, but I don't think that anyone has ever suggested that I don't have a professional temperament and demeanor in the courtroom. So I think that the level of experience that I have is deeper, and my life experience suggests that I have an ability to listen and comprehend and research and provide in-depth assessment and wisdom in the cases that will be brought before me. I do not have extensive jury trial experience. I have thousands of bench trials that I have handled over the 25 years that I've been an attorney. I've argued numerous cases to the 5th District Court of Appeals and 2 cases to the Florida Supreme Court. So I have extensive experience, and I think that I've shown that whatever area of law I'm assigned to, I'm capable of learning it and excelling at it. And so I think that those qualifications mean that I will work to the very best of my ability to be as good a judge as any on the Ninth Circuit.
What's the name of your 501c3?
A Chosen Child, Inc.
Okay.
Wanted to follow up on the experience question. So have you ever done any criminal cases before?
I have not.
Okay. How important do you think it is for a judge coming into the job to have both civil and criminal experience?
I think that no matter what candidate you're talking to, there are areas of the law they would have to learn as a circuit court judge if they're moved from one division to another division. No candidate is going to be fully competent in all of the areas that the circuit court draws upon. I do think that there are a lot of candidates who have experience in criminal law and relatively few that have deep experience in the juvenile and family court system. So how important is it? It's important that we have a strong criminal court, but it's also important that we have a strong juvenile court, a strong family court, a strong civil court.
Ms. Tennis, how about the variety of cases that you've handled?
Well, I have 22 years worth of experience in criminal court. I started at the public defender's office. When I went into private practice 20 years ago, I got into family court, I got into dependency court, I got into delinquency court, and I've done my own appeals, both in writs in criminal cases and appeals in dependency and family cases. So certainly I would stack my juvenile and family record up against Ms. Strowbridge, although I will acknowledge I don't run an adoption agency. I am a trial lawyer. The issue related to the civil side of things versus the criminal, in my experience and just in front of dozens and dozens of judges over 22 years in all facets of the law, in my experience, judges who have some experience in criminal court tend to do better. And I think if you look at the polls, the judges who fared the least well had fabulous backgrounds, had wonderful personalities, had immense talents, and they struggle in criminal court. And I think that's just a reality of the job. So I personally think it's very important when it comes down to issues that might affect your industry, for example. When you're looking at decisions that have to be made about keeping the First Amendment, keeping the press out, letting them in, do we cover the jurors' faces, do we let them be shown, is there a gag order for some pieces of evidence, or are we going to hide their names at the end of the case? These are decisions. I mean, I had the benefit of watching Belvin Perry day in and day out as I covered the Gacy Anthony trial live. Actually, I covered the Zimmerman trial live, giving analysis also. So it's from a outsider's perspective that I got to see the two biggest cases that will probably ever hit Central Florida and how those experienced judges dealt with some issues that are very peculiar and particular usually to criminal court, and some of those First Amendment issues and the media issues are an example, I would say, of things that you really want to have an experienced judge be dealing with.
What was your assessment of the way Judge Perry handled those cases?
Well, he was fantastic, and that was not just my opinion. Obviously, everybody thought that he did a fantastic job, but it was a real teachable, learning time for me. Because instead of your typical talking head gig where you go in at 5 o'clock and they ask you to talk about something that you may or may not have seen, I got to actually sit there every day, all day, watch it in real time, and give analysis as to what both of the sides of the arguments were, what Judge Perry may or may not do, and then give some explanation as to why he may have made the decisions he did. I think that his decision at the end of the case to keep the names private for a period of time was somewhat controversial at the time. Would he make that decision again, having gone awry once those names came out? I don't know, but I know that he had the job of making that call in a jurisdiction where nothing like this had ever happened before, and he dug deep into the many years of experience he had both on the bench and working in criminal courts to try to do the best he could with that very tough, decision.
If you had been wearing the robe at that time, would you have made that call?
Well, I'm not permitted to actually tell you what call I would have made. I can tell you that I'm a criminal defense lawyer. So the Constitution and Amendments 1 through 6 in particular are my bread and butter, my life, my passion. So any request by anybody to curtail the First Amendment or any of the others is going to be seen by me as something to very, very seriously look at. And I think that I'm not going to second guess by any stretch Belvin Perry in any decision that he's ever made. But those are decisions that I would not take lightly because constitutional rights our freedoms, and it's particularly in Florida with the laws that we have related to the citizenry's right to know. We see it getting litigated right now in Tallahassee. I mean, these are important issues.
Ms. Strowbridge, is there anything in particular in your background that may have prepared you to deal with questions of legal rights, touching on women or minorities?
Certainly in the areas that I've worked in termination of parental rights and in family law, we're often dealing with those issues and dealing with constitutional issues very frequently. The right to the care, custody, and management of your child is a fundamental right under the U.S. Constitution. So any time that you're dealing with the Department of Children and Families, or you're dealing in a private adoption context where termination of parental rights might be involved and women's rights might be involved as well, you're certainly going to be embroiled in that. Most of the cases that I deal with involve women who are in poverty, who have substance abuse issues. Many of them are minority women. We have to be very conscious of protecting their rights in that process. Often I'm involved in the DCF system, and so I've represented many people who were dealing with conflicts with the Department of Children and Families, and so that certainly has a lot to do with it. If I could, Mr. Owens, I'd like to respond just briefly to Ms. Tennis's comment about the highest-rated judges having criminal experience, and simply point out that my late husband, Bob Waddles, was one of the highest-rated criminal judges in the Ninth Circuit, and he had no criminal background when he took the bench. He learned to be a criminal judge, and he was one of the top criminal judges on the Ninth Circuit. So I don't think that's accurate, that criminal trial background or jury trial background is necessary for someone to be an extraordinary judge. I think it has to do with their desire to become the best they can possibly be wherever they happen to be placed. And in addition, I think that the chief judge has to carefully consider the background of anyone who's elected or appointed to the court in the assignments that he makes. So if I don't have extensive experience in the criminal courts, then the likelihood is that he's going to seriously consider openings in the family court or the juvenile court for me because I have extensive experience in those courts.
I wanted you to have a chance at the question that I asked Ms. Strowbridge about anything in your background that has particularly prepared you to deal with questions of legal rights involving women or minorities?
Well, I mean, to a large extent, I feel that's been the crux of my profession, my career. Yes, I totally agree with Patricia's analysis of the fundamental rights of parents in dependency court, particularly when you're talking about terminations. I typically would have gone into those cases from a different perspective. I would have been actually fighting on behalf of the parents whose children were being taken. And I've had very many opportunities to fight for parents' rights, biological parents' rights, to the care, custody, and control of their children, which is not dictated just by the U.S. Constitution, but the Florida Constitution and our right to privacy makes parental rights in Florida, supremely strong, which is why grandparents no longer have any rights. So certainly have had a lot of work in that area, and my work as a criminal defense lawyer, whether that be pro bono for Kenneth Taylor, who was wrongfully accused of being a tourist rapist back in the late 90s, or whether that's court appointed in cases where people are accused of killing people and nobody in their right mind in the legal community would want to represent those reprehensible people. Those are the cases where I said this is the most important fundamental piece of our jurisprudence, is that everybody be presumed innocent until proven guilty, and everyone has a right to a zealous and effective lawyer who doesn't care what the press says, who doesn't care what the police say, who doesn't care what the neighbors say. They're going to do their job when they're appointed to represent somebody. I've represented many people who were not our community's favorite. And I stood by the Constitution, and I stood by those clients, and I couldn't be more proud of any of the work I've done than that.
What were the outcomes in those cases?
Well, it varied. I'm, I guess, proud, although that seems like a horrible, hollow word to use in the situation, to say I don't have a client on death row. I have a number of clients who are serving life sentences for crimes that called for and ultimately deserved life sentences. And those are hard cases to go through. It's emotion-packed. You've got defendants' families sitting next to victims' families, and high stakes and high pressure. So it's a variety of outcomes. A lot of cases, obviously plea to years in prison, but I certainly have a lot of clients who faced serious consequences and who are serving serious time in jail.
Ms. Tennis, have you ever been disciplined by the bar?
I have not.
Ms. Strowbridge?
I was. In 1994,
Uh-huh.
I had a situation in which a misdirected facsimile was sent to my office. This would be when facsimiles were brand new technology. That facsimile was sent to my office in December, and the previous March or May, the Florida Bar had issued an opinion that directed that misdirected facsimiles needed to be returned to the sender immediately, and it was probably 4 weeks before the facsimile was returned to the sender, and the opposing counsel filed a bar grievance. I acknowledged that I was unaware of the Florida Bar ruling, and I was provided with a diversion to an ethics class, which I took immediately. And from that point forward, I have had no issues with misdirected facsimiles ever.
What in your background has prepared you, Ms. Tennis, rather, to deal with business and regulatory issues?
Well, I run a business. It's a solo practice, but certainly it has all the earmarks of the problems and bureaucracies and administrative processes that any other business has. We deal with HR, we deal with payroll, we deal with taxes, we deal with regulations and licensing and health insurance and all of those things. As far as administrative law, I don't have a great depth of experience there. The only administrative law that I've dealt with routinely as a criminal defense lawyer would be DMV type issues. I've represented a few people who had school board issues and such as that, but that is not an extensive part of my background.
And you, Ms. Strowbridge?
Well, I've run two businesses. At one point, the combined businesses had 21 employees, and the combined businesses do have over $1 million in gross receipts. I have dealt heavily with the regulation of adoption agencies. They are a highly regulated industry. So we have audits and we have DCF reviews that are required annually, licensing that goes along with that. It is not just the management of legal personnel, but it's also the management of social service personnel. And I was the executive director of that agency and founder from the time that it came into existence in 1999 until just 2-3 months ago when I transitioned the executive directorship over to my law partner. And I am now the legal services director instead. My law firm is a partnership. I have that's 2 lawyers in the partnership. We also have all of the administrative duties, but it is not a small practice. The law firm currently has 5 employees and has had as many as 8 in addition to the staff of the agency. So I think that I have relatively extensive experience in both the creation of, development of, marketing of, and maintenance of businesses.
Could you, I'll start with you, Ms. Strowbridge. Tell us what in your background outside of your legal career is kind of your best asset that you would bring to the job of circuit judge?
I've raised 5 successful children. My oldest daughter I received from the DCF system when she was 12 years old. I was appointed as her guardian ad litem. She is about to turn 34 and still works in the adoption agency with me. My second oldest daughter is married and lives 3 miles from me with my 3 grandchildren, and my youngest 3 children, 23, 18, and 16, still live at home. I think that in the process of raising those children, I have learned a lot about life. As I joke with people, I've learned about accusations and sentencing and probation and appeals, all through living with them. Of course, I'm joking about that, but the reality of it is that that when you're raising children, you learn to be self-sacrificing. You learn to understand that there's always 2 sides to a story. You learn to be committed to excellence and the importance of being a role model and setting that example, setting a moral example. So they're always watching you. And we lived, my husband and I established a home where character was important, always. And I'm seeing the fruits of that now because my youngest child's going to be a junior in high school, and they're all successful kids. So I certainly think that that's the greatest asset that I bring to the table pretty much in any aspect of my life. And for a period of time, all of my kids were very active and involved in athletics, and for a period of time, my youngest daughter was a high-level competitive gymnast, and I had to not only run my businesses, but also part homeschool her in order for her to be able to participate in her sport and travel with her for what she needed to do. So I think that I've been able to juggle the demands of a high-powered career as well as the most important job I have, which is being their mom.
Same question, Ms. Tennis.
First of all, I would have to give props and kudos to Ms. Strowbridge because I honestly can't even imagine what it would be like to run a business and raise 5 kids. That's an incredible accomplishment, and nobody can take that from her. I don't have children, and I'm married for the first time at 44 and somehow managed to avoid even becoming a stepmom at some point. What I do bring to the table, though, I think in my background is diversity, and I may not look like that, but one of the things that drove me the craziest about my law school experience was that I didn't have that get a car at 12, soccer mom background experience. My family is relatively not well off. I'm the first person in my family to go to college, not to mention law school. My family lives kind of in the boonies, frankly, in Alabama. And they hunt and they fish and they're wonderful. And when I go and visit, I hang out with people who've been hunting all day and there's blood everywhere. It's a very different place from where most lawyers I know came from. I also travel extensively. That is one of my passions outside of the law. I've been to 13 countries in South America and Central America. I've traveled to the mountains in Thailand with a relief organization and slept in a sack in the woods for a week at a time, bringing food and water and animals to villagers who'd never seen people, not to mention animals that could actually carry their water for them. I've been to Easter Island, I've climbed Machu Picchu, I've backtracked through Peru for 6 days with villagers. I mean, I've been a lot of places and seen a lot of people that don't live anything near the way we live. And the things that we take for granted are immense. And back to the demeanor issue, I believe we have not a lot of huge problems in our judicial system, but one of them is that we have judges that aren't in touch with the people that are before them. These are not wealthy people, they're not well-spoken people, and more, they're not represented people. If you can't relate to folks that don't speak lawyerese, and you can't relate to people who don't happen to have lawyers who you golf with standing next to them, you're not going to be doing real justice. And I think our poor folk are still getting the short end of the stick. I think our English as a second language people really get the short end of the stick in the courtroom still. And I think I have a special sensitivity due to that, just the parts of the world that I've seen and what I've done.
I'm curious, do you speak any other language?
I so wish. I've got that Rosetta Stone sitting at home, and every time we book a trip to Buenos Aires, I'm like, I'm going to do more than order dinner this time, and I don't have an ear for it, and no excuses. No, I do not, and it's lamentable.
Ms. Strowbridge?
I read Spanish. I can speak it, but I'm too slow to engage in conversation with people. But I understand it when it's being spoken around me.
Ms. Tennis, piggybacking on what you were talking about before, do you think that the court system does a good job in delivering equal justice for all, regardless of race, gender, and ethnicity?
Well, there's nothing intentional about bias in the system. There's nothing intentional about the fact that if you are a Hispanic speaker, you're going to be sitting with a lawyer who likely doesn't speak your language. When the interpreter gets there, they're going to be needed in 3 other places, and the judge is likely to say, let's call the interpreter case to get this case over with. You are likely not to be able to have any real meaningful dialogue with an interpreter who may or may not be from your part of Latin-speaking culture. That's just a reality. And at this point, lawyers, and typically those would be public defenders, are overworked and don't necessarily take the time or have the time to stick up for those folks. Interpreters have 3 other places to be, and they're not doing a very good job of saying, hey, judge, wait, I haven't had a conversation with this guy. I don't know, we haven't even begun to explain what's going to be happening to him. And the next thing you know, you're off and running, and the judges, who typically don't speak these second languages, won't know whether or not things are going well for the person either. So I think that's an area of particular concern to me. But just in general, I think legal services to the poor are overworked and understaffed, and we have many, many, many more people who are turned away by legal aid than they could possibly take care of. And although our bar does a magnificent job attempting to help that population, I think there are still problems. And judges who are sensitive to it are critical.
Same question to you, Ms. Strowbridge.
Would you mind repeating the question?
Sure. Basically, in short, do you think that the court system does a good job delivering equal justice to minorities and the poor, and regardless of race and gender, et cetera?
No. I think there's 2 standards of justice that we have. I think it is primarily differentiated based upon socioeconomic status. I think that minorities that are well-to-do will do fine in our criminal justice system, but by and large, our lower socioeconomic citizens are minorities and women, and I think they struggle mightily to find justice in the system. Often they're unrepresented at all. The Legal Aid Society is grossly underfunded, and I am regularly called upon by legal aid to provide services that the attorneys don't have expertise in. So when people are facing issues related to adoption or termination of parental rights, sometimes a grandparent who's trying to raise their grandchildren and has hit problems because they don't have legal documentation that allows them to make decisions relative to that child. Can I help them? I can't even help them because the home study that would be required is not something that I as an attorney can provide, and there's no money to provide that. So I absolutely think we have a 2-tiered system, and it's primarily socioeconomic. And yes, of course, it impacts minorities and women significantly more.